Hey everyone, Ali here. So we're going to talk about contract disputes and how to avoid them. It's almost become commonplace to see disputes amongst different parties, and we see a lot of them here at the law firm. Thankfully, we're very successful in defending our doctors or taking action on behalf of them. But if you can avoid a contract dispute, you are well ahead of the game. And so, really important that we talked about this today and how to avoid these disputes. So, there's a couple of scenarios that are most commonly result in contract disputes. So the first has to do with non-compete clauses with either your employer, which we'll talk about, or with your employees if you're the employer, or if you're buying a practice, the non-compete with the seller of the practice sometimes becomes an issue. So we're going to talk about that. Then we're going to talk about partnership agreements and how contract disputes come out there. We're going to talk then thirdly about employee disputes, and that we put this under contract disputes, but it can be under some other titles as well. But we'll talk about that, especially with associates and independent contractors. And then finally, with your landlord, how do you avoid issues with your landlord? So those four are going to be the topics we're going to go through today, so that you have the strategies you need to avoid these disputes. So right off the bat, I want you to know something really important. A lot of these contract disputes really start by not having a contract that protects you or your other party, the other party that you're dealing with well. And what I mean by that is that they're not, maybe reviewed or drafted by attorneys, or one side maybe doesn't have an attorney, and so the contract is more one-sided than not. And what we have found is that when contracts are more one-sided, there will always be a little one-sided, for one party or the other. If you're a landlord, the lease is going to be a little bit more to your advantage than the tenant because it's your property. If you're an employer, your employment contract is going to be a little bit more to your advantage than the employee's advantage, just because it's your office. Some of those things are just known to be the case, but if it's too much in one direction or the other, that's when disputes start. And a lot of times, these happen because one side decides not to hire an attorney to help them, negotiate and go through the documents. And it's a vital part of this negotiation. So right off the bat, I would advise you, your chances of getting in a dispute if you don't have an attorney or the other side doesn't have an attorney is really, really great. Now, in the short term, it may not seem that way. You might be able to get 3 months, 6 months, a year, 2 years, depending on what the issues is. You might be able to get away with that many years without any problems, but eventually these disputes occur. All right, so let's jump into it. So non-compete clauses if you're in an employer-employee relationship. So as most of you know, many states around the country do not allow non-compete clauses to be valid and to be inserted in employment agreements. Some states are much harsher about it, like California, but some states are a little bit more relaxed, like Georgia, Hawaii, Nevada, Texas, or whatnot, New York even. So you have to balance, where you are with the rules of that state, and you can't say, okay, well, this is the rule in California, so it must be also the case in Texas or other places, or vice versa. That doesn't really work that way. And so what happens is that if you're in a state that does not allow non-compete clauses, but you receive a contract with a non-compete clause, or you are giving a contract with a non-compete clause, that can have some really grave issues, because you're relying on the fact that you think that employee, for example, if you're the employer, will not compete against you. The employee, on the other hand, may know that the rules don't apply to them, at least from a non-compete perspective, and so they're planning on competing against you anyways. And so what happens? Well, they resign or you fire the employee, and then that employee gets up and goes and opens up an office down the street, or above you or below you, or next door to you, and so then these issues arise, and suddenly you're in litigation or whatnot. So again, really important to have these drafted carefully and appropriately for your state, and making sure that the other side understands what's in there. Because if you're not allowed to have a non-compete clause, then maybe you put language that protects your intellectual property. Or if you are allowed to have a non-compete clause in your state, maybe making sure that your radius is short and viable, as opposed to broad and overreaching, which would then allow, not allow it to be valid. So keep those things in mind, with regard to non-competes. So now let's move on to the next scenario where non-competes become an issue. Non-competes can also become an issue in a transaction where someone's buying a practice and someone's selling a practice. Now, the law in many states is that if you are selling goodwill, then you can attach a non-compete to the seller. So if you're the buyer, you can say, hey, Mr. Seller or Mrs. Seller, you cannot compete against me after you sell me that practice. Well, that makes a lot of sense. We don't want people to sell businesses and then, go down the street and open up again. They're going to take all their patients back, and then there's no reason having the sale occur. Nobody would buy a practice in those scenarios. So there are those scenarios. Now, what happens is that sometimes those radiuses for those non-competes are really, really small. And if they're small, then the buyer may not realize what they're really signing up for. And here's my advice to many of you, is that if you're buying a practice, make sure your radius is large enough so that if you have patients who you think will follow the seller, that they really have to work hard to go find that seller. Maybe it's a 15, 20, 25 mile radius, depending on your location. If you're in the middle of a big city, maybe you don't need it to be as big. If you're in a rural area, maybe you do. As a seller, it's important for you to know kind of what you're getting yourself into as well. And I would encourage you to be honest about your plans. If you're planning on retiring, then retire, right? And don't negotiate the non-compete because you're not planning on working. If you're planning on helping a friend every once in a while or doing something else, then be honest about that as you have these discussions with the buyers so that the non-compete can be drafted well. Because if it's not, then guess what? There's going to be disputes, and then there's going to be litigation along that line, right? So hugely important. All right, next, let's talk about partnerships. So this is another area where we see a lot of contract disputes. And it's funny about partnerships is that it never happens early on. You can go a year, 2 years, 3 years, and everything's fine, but then eventually there's disputes. And our goal at our law firm is to make sure that those disputes do not happen. And we, knock on wood, have a really good track record of making sure those don't happen. And the reason is because we walk you through all of these different scenarios well beforehand. So what are some of the things that cause problems? Well, spending authority, dissolution arrangements, income splits, hugely important, which we're going to talk about, how assets are handled, and then more importantly, what are the roles and responsibilities of the office. So if I had to break down a partnership in terms of disputes, of the top disputes, if you will, it would fall into these categories. Money, right? Just like in a family divorce scenario, partnership disputes mostly surround money. And there's a couple of ways that money comes into play. Well, of course, the salary that each partner gets could be an issue, but the income splits, or the profit splits, I should say, are really where the big problems lie, right? So how are profits split between the partners? Now you might say, well, Ali, we're 50-50 partners and it should be a 50-50 split. And really, it's not that easy. It's not that easy because life changes. Somebody gets married, somebody has children, somebody wants to travel more, somebody wants to work more, somebody wants to do more high-end cosmetic, let's say, cases, or they want to go into a different kind of practice area. All these things can change how profits are split between the partners. And so if you're not careful, then it could cause some real problems, right? It could cause some real problems. And so it's important to work through those things in the very beginning before you get into it. So money is the top one. The next is just the structural, the structure of the partnership. Are you shareholders in a corporation? Do you have your own corporations and you enter into a partnership? How is that created? Because each one of them has its pros and cons in terms of how the partnership operates and how much flexibility each partner gets. So really important to think that through. And then the third part of partnerships is what happens with the roles and responsibilities. Who's responsible for what? when are they going to do it, how are they going to do it, and how are those responsibilities split between the parties. You don't want to leave it up to chance. You really want to get nitty-gritty with it. All right, let's go into employee disputes with regard to associates and independent contractors. This is really common when people hire employees, associates or independent contractors without a contract, or something that they don't really pay a lot of attention to. It's really important that you have language regarding what the term of the employment is, how much the compensation is, and no unclear terms. How the contract can be terminated by either party, what's considered a violation. All those things need to really be spelled out. And if you don't have those, or they're really, really broad, then this is going to be an issue, and can cause problems for both sides. There's a trend, especially with group practices, where they give contracts that are 5, 6, 7 years old, 7 years long, and it's just too long. It's just too long. People's lives change, very quickly, and so you're just setting yourself up for trouble there. If you're an employee, I would never sign anything longer than a year unless you have an out with, let's say, 30 or 45 or 60 days notice. Anything more than that, you're really rolling the dice that your life will not change at all, and that's just not the case. So just make sure that's in there. More importantly, make sure you have mediation or arbitration language in your contracts as well. Okay, next, let's talk about contractual disputes with landlords. Now, this usually is governed by your lease, and again, a lot of times, we see this, and it's really kind of, head-scratching situation when we hear that someone signed a 10-year lease without having a professional look at it. And quite honestly, it just doesn't make sense to me. Yes, you want to keep things going, you want to keep things smooth, you want to save a few $1,000s, but in the grand scheme of things, when you're thinking about your obligations 20, 30 years with a landlord, where they have a lot writing and you have a lot writing because it's your practice, it just doesn't make sense not to have a lawyer look at it, not to be helped by a commercial broker in the initial business negotiations. And so just don't do that. Make sure you focus on hiring the people to help you there. Hugely important. We have seen language where the tenant had to pay a percentage of the sale price to the landlord upon the sale of their practice. We've seen them pay extra for common area expenses and other things that they should have never. We've seen year-to-year increases that approach 10%, but they were told that it was a lot less than that. So just a lot of things that just are really scary. So make sure with your landlord you would definitely have someone looking at your lease. All right, those are the top areas. I know we went through a lot. There's a lot of detail in each of those, so feel free to reach out. Be happy to chat with any of you regarding these details and how to avoid these contract disputes. Thanks.